There are lots of reasons why religiously opposed groups might say, like, we don't want this kind of expression next to our homes. And so the RLUIPA law was passed in order to push back and to guard against that kind of invidious religious discrimination of using land use ordinances to prevent religious expression. And I don't want to impute a motive in this case, but it's not unreasonable to say that in many such cases that opposed neighbors could have legitimate concerns about traffic and so forth, but some may be motivated by religious animus as well.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. You're listening to the Napa Legal Podcast, where we explore religious liberty from the perspective of faith-based nonprofits, and where we have also been increasing our special guest episode content, which is a lot of fun for me to do. So for today's special episode, we're joined by our guest, John Ketcham. John's a graduate of Harvard Law School. He's a Senior Fellow and Director of Cities at the Manhattan Institute. He also happens to be an alumnus of Napa Legal's Good Counselor Project Fellowship and a good friend. So, John, thanks for joining us today.
Great to be with you, Frank. Thank you.
Yeah. So first, we're going to talk about this Missionaries of St. John the Baptist versus Frederic case that we got to co-author a brief on. We'll get to that in just a minute. But I thought first, if you would just tell us a little bit about your own background, your faith, how that factors into your professional work, and then maybe a little bit about the Manhattan Institute and what you do there.
Sure. Thank you. So I am a cradle Catholic. I have always had the faith as an integral, central part of my life. I was a sacristan at my local parish of St. Francis of Assisi in Astoria, Queens, for well over 10 years. I still attend that parish, and the one I was baptized in. I'm very much rooted in place. I'm the treasurer of the Catholic Academy that I went to as a youngster, right next door to the parish. So home is very important to me, and the ability to pass on the good that I've inherited in my home is core to how I see my role at Manhattan Institute. I was born in a time in New York City when things were getting better with every passing year, when the city was getting safer, more prosperous, more dynamic, more vibrant. And I think we've taken for granted a lot of the policies that made that a reality, such that we've lost some of that vibrancy, some of that safety over the past 10 years since the pandemic, certainly. And I find that it's really important to come at this work with a sense of mission and purpose, uh, and to advance the common good in a way that is different than what you may see in from other publications or from other angles. Um, I think it is really vital to focus on the things that government does really well and the foundations, like things like public safety, to making sure that our streets and subways are clean and safe, not just because it allows for economic prosperity and dynamism, but also because it allows for families to thrive, for children to go to school and to feel that they have a sense of attachment and affection to a place that is their own, like I did growing up. And so I find myself engaged in the Burkean intergenerational project of inheriting this great treasure of a city and a civilization within the Western civilization, of course, and of taking the best of that and advancing it and passing it on for posterity's sake.
I think when we first met, we bonded over that shared love of localism and place. And you were one of the first people I had met who had such an affinity for rootedness in one's home and place, who came from a place like New York City, which is different. A lot of the localism is rooted in rural affections. So great to hear a love of place and from a city dweller.
Yeah, well, I think a healthy political outlook, a healthy conservatism in my sense, stems from a love of what is working well enough, right? Human beings have so many weaknesses that it's a small miracle that things work as well as they do, right? And so we should never look askance at that. We should always be grateful for the many good things around us. And of course, that is key to how I see the Christian faith. Like, we owe so much to God. We owe our existence. We owe our very being to Him. And so we reflect that in the works that we do, empowered by His grace, and by the faith that we have in the one Lord.
Great. Well, I know that a lot of your work is policy oriented, and you manage to be extremely prolific from Manhattan Institute's City Journal to you have a regular column at the New York Post, right?
Yeah, I write for the Post 2, 3 times a month at this point. It's a lot of fun. I go from
Yeah.
dense policy paragraphs to one sentence paragraphs.
Mhm. Yeah, right. It's a big switch. But despite all the policy and like the public writing work, you still manage to be involved in legal work, not as a lawyer representing clients. Like me, you're kind of a pseudo practitioner of law a little bit. But you do a lot of work with amicus briefs, right, at the Manhattan Institute. Can you tell us a little bit about Manhattan Institute's center that focuses on that kind of work?
Sure. So our constitutional studies division under Ilya Shapiro and Trevor Burrus have it really has mushroomed in terms of its output and its impact on the many cases that it opines on. So we're up to over 50 amicus briefs per year, and that ranges from everything from economic liberty to free speech to some of the things that I work on more closely, which are pediatric gender medicine issues and social transition in public schools, the widespread practice of calling children by different names and pronouns without parental knowledge and consent. Uh, we think that's unconstitutional as a matter of parental rights. And so we have filed briefs on that across the nation and including at the Supreme Court. But we are also very much just with our ear to the ground for property rights cases. And so this case that came up, uh, Missionaries of St. John the Baptist v. Frederic, came across my desk, and I just thought it would be perfect for the two of us to put our heads together on. It was perfect for our two institutions.
Yeah, thank you for doing it. I'm so like we had said offline, but we're Napa Legal's pretty choosy about so a case has to be really right up our alley for us to weigh in as amicus, but this was perfect. So yeah, from my side, we'll talk about this maybe a little bit. I focused on the RLUIPA issue, that's the Religious Land Use and Institutionalized Persons Act. But from your standpoint, I know you do a lot of land use work at Manhattan Institute. So why did this case in particular strike you as an important one to get involved in?
Well, it is part of a broader array of issues that we work at Manhattan Institute on small interest groups that prevent development. So across the country, you have what are known as not in my backyard groups, many times opposed neighbors
Yeah.
who band together and thwart new development from happening. And if you add up the sum total of those effects, you get a country that is severely supply constrained in terms of new housing. That is why it is so difficult to find a starter home. That's why it's so difficult in many cases to find a house within reach for young families. And that has some serious ramifications on our society. We are seeing young people who are dejected. They feel hopeless in many cases that they can't get a start in life because everything is just so expensive and so out of reach. And so, in keeping with our emphasis on economic dynamism, we are pro housing supply, we're pro development. And this particular case presents a similar issue where you have NIMBY neighbors that are opposed to the construction of a modest Lourdes grotto on a church property for an arcane uh, zoning reason because it's not located on an arterial street. So that to me presented the ideal fact pattern to say, hey, we can't allow groups of opposed neighbors to thwart religious expression. And I thought, who better to raise that issue with than Frank DeVito and the Napa legal team?
Yeah, well, thank you for bringing us in on this. So, yeah, I want to talk a little bit about the factual background. You hinted at it a little, but I was struck by the modesty of the proposal that was rejected, but also by the process. Can you talk a little bit about what actually happened? Because if I understand correctly, not only was this proposal not really a big deal, but I think initially the local zoning authority approved it. Is that right?
Yeah. So the Missionaries of St. John the Baptist, it's a Catholic religious order that has a particular devotion to the TLM, as I'm sure you're happy to know. Uh, they wanted to build this Lourdes Grotto, it about 16 feet by 39 feet on their property. Uh, and so they filed for the construction of this property with the city of Park Hills, Kentucky. Now, the zoning ordinance in Park Hills requires that religious structures or buildings for religious worship be located on an arterial street. Um, so uh, they sought permission from the local zoning board. They received permission from the local zoning board, but after they received that permission, that approval was challenged by a group of neighbors on the grounds that the land in question was not located next to an arterial street. And so the Kentucky Appellate Court and the Kentucky Court of Appeals agreed with the reversal of that permission from the zoning board. And so at this point, the only relief for this religious community is the Supreme Court of the United States.
Yeah, no, I'm interested. So an arterial street is something like a highway, right?
Yeah, it's like a large roadway you can think of. So if you have a venue that with a lot of cars going in and out, you would want there to be an arterial street to alleviate traffic congestion. That's the reason.
Right. So here I'm interested because at least if you're in like a single family housing, kind of residential area and somebody wants to build an apartment complex, then I get the concern that, parking, congestion, traffic, you need to have a plan for this. Okay. This is an outdoor grotto, right? It's like a statue and some walls around it. Like what possible, am I missing something? What traffic or parking problems would a grotto create on a property that already has religious worship on it? Like, would this attract new crowds? What are we talking about?
So the existing structure was grandfathered in before
Hmm.
the zoning ordinance. So because this is a new structure, it would normally have to uh, comply with the zoning ordinance. Um, there are lots of reasons why religiously opposed groups might say, like, we don't want this kind of expression next to our homes. And so the RLUIPA law was passed in order to uh, push back and to guard against that kind of invidious religious discrimination of using land use ordinances to prevent religious expression. And I don't want to impute a motive in this case, but it's not unreasonable to say that in many such cases that opposed neighbors could have legitimate concerns about traffic and so forth, but some may be motivated by religious animus as well. Um, but in a society where religious expression is a fundamental good, where even going back to Tocqueville says that religion is necessary for the dispositions, the habits of Americans to govern themselves. He called it an integral part of the art of being free. So the benefits of religion are quite diffuse, right? They benefit the majority of the country. And so it's important to protect that against minoritarian groups, specialized small interest groups that may have a reason to oppose it.
Yeah. Now, When in my part of the brief, I wrote on the RLUIPA issue, and I just want to touch on it for a minute to just kind of bring this out. So the way I see the problem is, you're right. If you look at the text of RLUIPA, if you look at the legislative history around it, it's pretty clear that this statute was passed pretty much for exactly these kinds of cases to make sure that you're not using local zoning laws as a pretext, or even not a pretext, but as a way to burden religious use of property, right? So the issue I see here is, well, there are two legal problems. One I didn't touch on so much, but I think the the fact that you have to prove that the burden on religious exercise is a substantial burden, and they've made that test quite high. It's a problematic threshold because this is supposed to protect religious land use, but the religious organizations have a pretty high burden of proving that this even rises to the level of substantial burden. So a lot of the time, the way this is tested, you're never going to get over that threshold. RLUIPA is effectively useless, I think, in most of the cases like this where it comes up, if it's interpreted the way that Kentucky interpreted it. Is that how you see it as well?
Yeah. So, the Kentucky courts took a very narrow view of substantial burden using the Sixth Circuit Livingston test, which you argue in your part of the brief that is the inappropriate standard, essentially eviscerating most of RLUIPA's protections in practice, such and basically not giving the protection that its enactors intended.
Yeah, I think it gets some of the analysis gets really confused because you'll have courts, and I think there's some of this in the Sixth Circuit around Livingston, where they're taking the definition of substantial burden from case law that's interpreting the institutionalized persons part of the law, right? So RLUIPA both protects religious land use and prisoners' religious rights, which are very different. It's kind of odd that they're in the same statute, but the result is that a substantial burden on a prisoner's religious right is usually analyzed under the guise of, well, basically, are they being coerced not to practice their faith or to give up, core beliefs or practices? But that doesn't apply to religious land use, right? Very rarely is a zoning law, some kind of land use ordinance going to actually make a religious community abandon its religious principles or be coerced to not practice its faith. It doesn't really make any sense. Other circuits have pointed this out, but the practical effect is this test in Livingston. One of the ones that really bothers me is one of the prongs is courts ask, well, could the land use be modified, right? Like it's not a substantial burden if you could just make it smaller or put it somewhere else on the property. But you could say that about pretty much any religious proposed land use. Like, oh, no, make it smaller. No, put it somewhere else on the property. You could really make a religious organization dance all over the place before it's going to rise to the level of a substantial burden. And it just, on a gut level, strikes me as a really unjust way to apply this law.
I agree. Think of it. The Kentucky courts basically told this religious organization, you could build a smaller version of your planned grotto elsewhere on your property. So like that means it's not a substantial burden. Well, excuse me, but who are you, courts of Kentucky, to dictate the manner of our religious expression? It seems to me on its face to be a imposition on the free exercise of religion. And of course, but if you define this substantial burden so narrowly, as the courts did in Kentucky, then even on its face, it's not going to pass the muster.
Yeah. And there's an interesting case, by the way. I don't know if you've seen it. It just recently was appealed to the Third Circuit, but out in Western Pennsylvania, there's a Ukrainian Catholic Church community that has this big 40-acre plot. And it's a very good example of how this, make it smaller, put it somewhere else kind of plan can really gut RLUIPA. So this church had this property. It was basically functioning as a cemetery. Then they raised the funds to build a shrine and a conference center and all of that, but they were denied a couple times. Meanwhile, there's a labor union with a 20-acre campus down the road in the same district that got approvals. Shocking. But the interesting thing, if you look at the history in that case, they proposed a shrine project. It was shot down. So they came back the next year, proposed a smaller one. It was also shot down. And then they came back and approved it like a year and a half later, but they approved it with, okay, but the shrine can't be more than 5,000 square feet, and you have to put this and that here. And it's like, this is to say that this is not a substantial burden to have like local governments telling you exactly how big to make your church. Like to me, it's kind of absurd. But I think that's the result of a test like Livingston, right?
And this is why the St. John the Baptist case presents an ideal vehicle for the Supreme Court to clarify the appropriate standard of what constitutes a substantial burden. It seems to me quite obvious that Congress enacted RLUIPA because of highly discretionary zoning decisions that often involved invidious discrimination against religious groups. And this is a way of getting around that intent in a place like Kentucky, where they basically read that intention out by defining substantial burden so narrowly. So, as you write, there are several circuits that treat substantial burden analysis quite differently, and the Supreme Court has a circuit split effectively on its hands, and so it should decide which one to go with here.
Yeah, and you could either, right, the two extremes are make the substantial burden test so high that no religious org ever meets it, or basically make the word substantial obsolete and say any burden is a substantial burden. And while I wouldn't go quite as far as the latter, I would like a test that's much closer to the latter than the former.
It has to be
So,
reasonable.
best case scenario, Supreme Court grants cert in this case. What to you does a good ruling from the Supreme Court do to improve religious land use law going forward in this case?
Well, at the very least, it should make clear that provisions like requiring an arterial street are not sufficient to block the construction of a religious structure. And also, it would put an end to this nonsense of having courts dictate to religious organizations the size and the location of their proposed structures. That should be taken off the table. But as you say, a good ruling will not try to make religious organizations immune from zoning, from reasonable regulations, but will certainly um, tend to side towards the more robust protections for those organizations and their freedom to do with their property as they see fit for the well-being of their congregants.
Yeah, so then on the flip side, if the Kentucky case stands, what's the worst case scenario? Like what does this a ruling like this, what is the negative effect that this can have on land use going forward?
Well, other states, other circuits are going to be able to adopt a similar rule that basically guts RLUIPA, and you're going to wind up with more of the same. And another case will come up with similar facts that will eventually get back up to asking the Supreme Court for cert. So this problem is not going to go away if the Supreme Court doesn't grant cert now.
Yeah, I wonder, I know I've seen some writing that I haven't gone too deeply into. I don't know if you've looked at this, but that some people have argued that actually putting the initial burden on the religious organization under RLUIPA is inappropriate. I don't know how you would get around that. I suppose you could, if there's a burden on religious exercise, the burden is on the zoning board or the government to prove that it's not a substantial burden. I don't know if you can shift that legitimately. Do you think you can read the statute that way, or do you think that burden does belong on the religious org and it should just be more reasonably interpreted?
It probably should just be more reasonably interpreted, but to leave the burdens where they are.
Yeah, I think that probably makes sense. So I guess we talked about this more offline. You hinted at it a little bit, but I just give you a minute to make the case. So the devil's advocate in me is like, well, I'm generally pro development, right? We certainly need housing. We're seeing a crisis and a big conversation around the lack of affordable housing, especially for younger people trying to buy their first home, right? But I guess on the other side, I do see the need for neighbors to say not in my backyard to certain things in certain places, right? Like I live in a beginnings of a rural area in Pennsylvania, and it's a lot of farmland. As farmers have a hard time keeping up that farmland and making ends meet. Developers come in and they turn a lot of farms in my neighborhood into Amazon warehouses and increasingly now data centers. And that's a problem because you can't undo it, right? Once farmland is a giant block of cement, you can't really undo that, and that's a long-term issue for our communities. So I can see the need for this sometimes. So make the case for me why generally we should be in favor of development versus approving of these NIMBY neighbors.
Zoning laws have their grounding in the police power of a state, health, safety, welfare. To exclude incompatible uses of land in close proximity is a legitimate exercise of that police power. You can't have a hazardous chemical factory right next to a home, right? It would be reasonable for a local government to separate those uses for the health, safety, and well-being of its residents. That said, local zoning has basically become a means of exclusion. It's become a way to keep out the types of housing and the types of people that communities don't want to have. Most often, this gets manifested in an antipathy to multifamily development, to apartment buildings, right? So you have requirements for single family zoning on large lots of property with very large setbacks that effectively force buyers to own more land and more house than they otherwise would want to buy. Now, this has a number of harmful consequences. If you are a young person looking to buy your first house, if you're looking to start a family, you can't find a house within reach in many parts of the country because of these zoning requirements that force the price of housing up. And it's by design. It's in order to keep only those who are wealthy enough to buy that house in that community so that there's a robust tax base and so forth. But many young people today are in a crisis of confidence about their society. And I think it's in no small part because we have made it so difficult to build new things. We are reliant on the housing, the infrastructure, the developments of the past because we are not willing to make the political trade-offs today to see new things be built in a cost-effective way. Um, so that's why in New York City, for example, you've got a large part of the housing stock that's built 50, 100 years ago. A huge building spurt in the 1920s is still dominates many, many neighborhoods in New York City. It's why we have a subway system that is well over 100 years old and doesn't build any new lines, but simply relies on the infrastructure that the private sector built, incidentally, over 100 years ago. So, in order to recapture a sense of confidence and purpose in our society, I think we do need to embrace development and building again. Like you say, Frank, it doesn't mean that we have to be sort of like unreasonable or uncritical of any new development, but it does mean that the default should be in favor of growth and development.
Yeah, I think that's right. Um, Great. So we will obviously be keeping an eye on this and may have you back if the Supreme Court hopefully grants cert and this becomes a Supreme Court case. But I guess before we part, I always like to ask if people are working on anything in particular outside the scope of this episode that they want to talk about. I know you're always working on a lot of things. Is there anything you want to highlight before we wrap up?
Oh, sure. Thank you. I'd love to come back. So I spend a lot of my time keeping a close eye on the happenings in New York City, particularly what Zoran Mamdani and his administration are doing. So we, in the last couple of weeks, were very involved in the LIRR strike, for example. Uh, it was a strike of public employees who work on the Long Island Railroad. They are already the best paid railway workers in the country. They were asking for quite outrageous, unreasonable demands. The governor had already agreed to most of their demands, but they were intransigent about the last bit of it. They wanted to get even the last bit. So they shut down the railway system for 3.5 days. And I think it bespeaks the need for us as Catholic thinkers to make more fine-grained distinctions
Hmm.
between different union types. So private unions operate in a market environment. They have many different constraints. The companies that they work with have to remain in business. Those companies can leave the city. They can go to other places. Government doesn't go out of business. So public workers can always try to extract more and more from the public. And I think that sets up an inherent conflict of interest against the common good, against the public interest. So we have to be more willing to look at public sector unions with a more skeptical eye as Catholics, and to develop a brand of Catholic social teaching that incorporates the common good against the narrow interests of public employee unions. And what we saw, at least in New York, was the governor making an admirable stand against simply giving away everything to the union's demands. But uh, that dynamic affects cities across the country, red states, blue states alike, and that kind of sharp interest group dynamic that impedes the common good is, in my mind, the single most important matter of urban governance in the United States today.
Yeah, I think that's a great point. Obviously, Napa Legal doesn't really work in this area, so the organization doesn't really take a stance on labor unions. But from a Catholic perspective, yeah, I think people interested in this read or reread Leo the 13th's Rerum Novarum, right? Because I think we have a real problem politically on unions that public unions get indiscriminately lumped in for good and for ill on both sides of the argument with private sector labor unions. And the result is that public unions get treated favorably, especially by people on one political persuasion. And then a lot of people on the right tend to just hate unions across the board as if it's just this evil thing. But you read Rerum Novarum in that section on labor unions, and it's really very profound, right? It's a private association of people who come together because they're so susceptible to their rights being abused by capitalists, by the landowners, right? That's very different than a public sector union, which where, like you say, it's not a capitalist, it's the government that is paying them. So I think the public sector union is just an entirely different thing from a labor union, and we would do well to reflect on that distinction because it's huge.
Public sector collective bargaining did not exist at the time of Rerum Novarum's writing. Right? It simply it came into being really in the mid 50s in New York City and then in the 60s with the federal system, and then exploded from there. So we do need to, as you say, reevaluate what we mean when we say union and not to lump together private unions that have associational interests and fraternal interests with public unions that uh, I'm afraid are quite successful at just extracting a lot of value and impeding accountability for results in places like New York. It's the reason, it's the principal reason, in my opinion, why New York City spends $42,000 per pupil and has results at or below the national average. I think that's a real shame, and it's a matter of interest to everyone, even if you don't have kids. Yeah, if you're a young Catholic family and you want to grow in a place like New York, well, you should want there to be a robust mix of different educational institutions available. And the fact that there's just this immensely lopsided system in favor of the public sector should give everyone pause.
Yeah. I mean, I feel that. My kids are homeschooled, so I don't have a direct interest in the public school system. My goodness, I mean, I think it's over 80% of my property taxes go to fund the school district. So we should certainly care where that money's going, how it's being spent.
Yeah,
All
about
right. With that,
$45 billion in New York City, all in, all in. So it's, yeah, it's a lot.
it's astounding. Yeah. Well, with that, John, thanks so much for joining us today. From the, you take up a lot of fights, legal and policy fights, from, as we've seen just today, from religious land use to public sector unions. You're doing really good work, and we're really grateful to have you here in the Napa legal orbit.
My pleasure, Frank. Thanks for having me.
And to our listeners, thank you as always for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it. If you like the podcast, subscribe to our channel on YouTube or Spotify or wherever you happen to be listening from. And we hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious freedom and particularly the work of faith-based nonprofit organizations. So we'll talk to you next week. Thank you for joining us, and God bless you all.